Okay, let's have order in the court. We'll hear for counsel for the appellant in our second case, Green versus State.
May it please the court. My name is Robert Rush. I represent the appellant, Danny Green. Here before the court to respectfully request this court to reverse his conviction as to 2 counts of attempted sexual battery, to remand those for a new trial, and to grant the judgment of acquittal as to count 2, which was sexual performance by a child. The central issue in this case was the time and the lack of evidence, that the failure of the jury to hear the evidence. This was a case that after a full work day, jury beginning at 8:30, sometime around 6 p.m., they were willing to give up their dinner and not look at an hour and 40-minute videotape, DVD tape, for one reason and one reason alone: time pressure. And they didn't look at it, and they never looked at it. The time pressure was such that defense counsel modified their strategy. Defense did not start their case to present the evidence until after 6 p.m. Defense counsel at first was going to present and display this in full to the jury. As the time pressure got greater, they were going to then just use excerpts. That wasn't available. They were going to play it during their closing. They did not. They never heard it. The jury did not review this piece of evidence, and it was not presented by counsel for one reason and one reason only: the time pressure that was created by trying to, as the trial court said, stuff a 2-day trial into 1 day.
Well, was the trial court expressing some frustration that the parties had told him that it was going to be a 1-day trial?
Yes, Your Honor.
I mean, in other words, this trial court wasn't expressing some guilt about having taken so long, was he?
Well, yes, Your Honor.
Let me ask the question this way. Wasn't it repeatedly stated during voir dire and throughout the beginning parts of the trial to the jury and to the court by the lawyers that this case would take 1 day?
Yes, Your Honor.
Now, how is it that your client is in a position to complain about the fact that, in fact, it required, in your view, more than 1 day?
Well, because...
What do you want the trial judge to do? To put off another group of jurors that he had scheduled for the next day, another group of lawyers? I mean, the court has the trial court has a responsibility not just to you and your client, but all of the people who have trials set that week.
That's correct,
You
Your Honor.
can't just say, well, these folks are going to take until Friday, and I'll just blow everybody else off because they're taking their time.
Yes, Your Honor. That is one of the factors that the Farrar Court in the second DCA was concerned about, and that's the absence of any record circumstances for continuing the trial. In this case...
Well, it was the fourth DCA.
Fourth DCA, thank you.
And what they said, that most of what they said in there was by their own admission dicta.
Yes, sir. That's correct. But in this case, the fact that the circumstances were one of the prosecutors had a trial starting the next day, the other needed time for preparation. Those were the only reasons given why the trial could not continue to the next day. And apparently both of them did a poor job of anticipating time.
Weren't there jurors? Didn't the trial court ask the jurors if they would prefer to come back or to stay? And didn't they all say that they'd prefer to stay?
Yes, Your Honor, they did. And that's part of what is problematic, because the court, in response to that, put additional time pressure on them by saying, good, I'm not going to go against all of you as long as everyone is committed to being as efficient as they can possibly be. This put undue pressure on the jury to be efficient, and there's evidence that they were concerned about that time, because the court went on to say, the bailiff says you're willing to give up dinner. They can bring you in something to eat. It doesn't slow you down there. And there was all of this emphasis through the trial court's comments on hurrying up, all the way through. And we can see that the defense counsel changed what they had previously announced they were going to do, that being to play this piece of evidence, which was relevant and critical piece of evidence. It went right to the heart of this case as to what this person's intent was in taking these photographs.
Did the defense attorney indicate that this would have been offered if there had been time by the defense?
That was not specifically stated, Your Honor.
My recollection, and I reviewed this a few days ago, but my recollection is that the defense attorney made the decision not to use this when the prosecutor announced that he or she would not be using this video in conjunction with cross-examination of the defendant. And the defense attorney just said at that time, well, if you're not going to do that, I'm not going to use it either. Is that incorrect?
No, Your Honor, that's not correct. But if the court would recall, there was additional comment by the trial court specifically as to that issue that certainly discouraged defense counsel from putting on that DVD. Basically, the court says that if you do so, the prejudice is going to be against you, and the jury is going to hold it against you. That's specifically what the trial court told the counsel. Let's hope the prejudice doesn't backfire. In other words, when you, referring to the defense, publish this thing, referring to the DVD, for an hour and 40 minutes, they, the jury, don't get annoyed with you. I can't fix that, the court said. In fact,
well, could the court have said that because perhaps the court perceived that the lawyers were spending time unnecessarily with evidence that really didn't have a bearing on the issue?
Well, the court actually stated that. I keep underestimating your all's ability to elicit relevant testimony. And the court says there comes a time when we've reached tomorrow. Again, really putting time pressure on these people. And interesting, one of the comments in the Farrell case was that when you get to the late hours, fatigue can impel the lawyer into subconsciously hurrying the process. We have that very clearly here with the defense counsel. They're hurrying. The court is hurrying. The court is specifically making comments to the jury about hurrying. Dinner's not going to slow you down. That's it. Be efficient. Efficient means that you've got to make a decision between productivity and cost.
This case ended, the jury came back with a verdict, what, was it about midnight or something?
12:07, Your Honor.
And that's late by Gainesville standards?
Yes, Your Honor, that would be. In fact, the trial court announced that, too. In his 350 trials, he's never had a jury go back to begin deliberations after 6 p.m. And in this case, it was close to 8 or 9 p.m. And again, this trial started at 8:30 in the morning. There was no compelling reason not to continue it over to the next day. Because is there any doubt that if this evidence was a piece of paper, a photograph, any tangible object?
Except that you told the trial judge this case would take one day. You think the trial judge was just there to do your case? I mean, the trial judge obviously had other plans for the next day with other people and other cases.
Well, Your Honor, I don't believe that's correct as to the trial judge. The prosecutor expressed the concern that one prosecutor had a trial and the other one wanted to do preparation. But again, what we were saying is, let's do closing arguments in the morning, let the jury deliberate. Instead of having a jury who is so anxious to get through this case that they don't look at a piece of evidence. Would that have happened if that was a photograph or a simple letter? If it was a letter, the jury would have reviewed it. If it was a photograph, they would have. They did not for one reason. That was because this piece of evidence took 1 hour and 40 minutes to review. It was simply a matter of the time pressure that they ignored a crucial piece of defense evidence. And those are the factors that the Farrar case went on. The counsel made an objection, and she specifically requested, can't we go on, can't we continue this to tomorrow, Judge? There's been no record circumstances that said it would be impossible. There's a witness that is unavailable. It was possible, and we know that it was possible because only one lawyer was going to make the closing argument, and that's really all that remained at that point.
Now, the jury deliberated for, 2.5, 3 hours, something like that?
It was approximately a little, yes, sir, a little more than 2.5 hours, I think, Your Honor.
And the verdict would appear to reflect that they gave considerable thought to each count because, I mean, they didn't find the defendant guilty of everything. I mean, they had varying conclusions on the different charges.
Your Honor, I think it would be easier if, in fact, they had come back with a verdict of guilty or not guilty. What they did, in fact, is they came back with a compromise. A compromise after now they were probably up 15 to 17, 18 hours.
Well, now, when you say they came back with a compromise, I mean, that's just surmise on your part, isn't it? Or? Yes,
Your Honor, and it's surmised based upon the fact that the state's case was that this was a completed act, and that's what all the testimony was. It was the defense's position that it never happened.
Well, what about your representation that they never reviewed this evidence? Does the record indicate that they didn't look at this videotape? Or?
Yes, Your Honor. It would have required them requesting the equipment in order to play the DVD.
Well, But I mean, you're saying since the record doesn't indicate they came back into the courtroom and requested it, that means they didn't view it, or
They did not have any means to view it, Your Honor.
does the record reflect that?
Yes, Your Honor, I believe it does, although I cannot cite the court to where it says that.
Well, now, exhibits are available, that are introduced in evidence are available for a jury to review, but does that mean they are required to review them?
No, Your Honor, I don't think they're
I
required
mean,
to.
maybe they, we don't know what they discussed. Maybe they quickly determined that whatever it was on that videotape wouldn't have a bearing on, or the DVD rather, wouldn't have a bearing on their decision.
Your Honor, it would be hard for him to have that discussion not knowing what's on the DVD. There was certainly comment in opening statements about the defendant's artwork. He discussed that on the stand. He discussed that these erotic photographs are something that he turns into so they look like different things. One of them is a tornado that is really, in effect, a photograph of a nipple, but by the way he arranged it and through his artistic endeavor, that's the way he presented it. But again, the time factor, you cannot get away from the fact that the jury was looking at this as a time issue.
But counsel, you have relied on the Fourth District's opinion in Farrar v. State.
Yes, sir.
In support of your position, the trial court erred in denying the defendant's request to continue the trial. Is that correct?
Yes, Your Honor.
But isn't the facts of this case distinguishable from the facts in the Farrar case?
Yes, Your Honor. In fact, there was more discussion there specifically about jury fatigue and some comments about that.
Listen, doesn't the discussion about fatigue by counsel in the Farrar case?
Yes, Your Honor.
That was the basis of the counsel's motion to continue because he was fatigued. He had been in court all day, and he was tired, and he couldn't continue. Is that correct?
That is correct, Your
Were
Honor.
there any basis to that effect in this case?
Your Honor, there would only be indications that you'd have to glean from the trial court's comments. The trial court certainly made some comments that would appear that the court was noting that the jury may be fatigued. The court said, I'm very, very concerned about going ahead and trying to stuff it all in tonight. I don't think that it's fair to anybody, including the defendant and including y'all. So the court was noting some problems there. And in this case, it is not just the fatigue issue, because there's several other cases that the jury went out late, but the court still upheld the verdict. The difference here is we've got a critical piece of evidence that, again, there's no other explanation as to why they wouldn't look at that, but that it was an hour and 40 minutes. There's no doubt that if it was a photograph, something else that they could have easily looked at, they would have, and then they would have discussed that. Because when the trial court says, you've got to be efficient, does that mean that you don't listen to anyone's arguments a second time? You can't reconsider anything, you're not going to reiterate, and as that clock starts ticking and it passes midnight, you come back with a verdict that is in fact a compromise. The Fourth DCA in Webb reversed the trial court's simply because the judge told the jury the verdict's got to be unanimous, it must be 6 votes, and it has to be rendered tonight. Now, we don't have a comment that explicit, but we certainly have a lot of arguments to that effect. And, Your Honor, I would just like to make one comment as to the judgment of acquittal. In that case, it's quite clear that the only evidence is a photograph. And it's a photograph of the genitals. The law requires actual lewd exhibition. The case law is clear that mere nudity is not enough. The Schmidt case discusses that. The Schmidt case, the issue was whether or not there was probable cause to get a warrant. In this case, the issue is, did the state, with every reasonable hypothesis, with every inference given to the state, did they exclude every reasonable hypothesis that this picture was anything more than taken for art purposes, because there is no factor in it that would make it anything more than a photograph of nudity.
Well, is that a jury question or is it a question for the court?
Your Honor, I think it's a threshold question as to whether or not there was actual lewd exhibition as contrasted with a simple photograph. And I think that fact, that threshold wasn't met, so that it should not have been a jury question. I'll reserve.
Okay, we'll reserve the balance of your time, Mr. Rush.
Thank you, counsel.
Not much of it, but we'll reserve it.
Thank you.
please the court, my name is Alan Dakin, and I have the pleasure of representing the state of Florida in this case today. I think that the state would respectfully disagree somewhat with the characterization of appellate counsel with regards to the factual circumstance that we had concerning the court's exercise of its discretion in this case. And I think Judge Padovano basically identified precisely what the problem that the court faced in this case was, and that was that the parties initially identified this as being a one-day case, number one. And number two, there were problems, not just the prosecutors having cases going the next day, which is a considerable problem. What goes on the next day? What happens to those cases? But also, there were two jurors that expressed that they would have hardships. They could make it, yes, but they would have hardships. There was one juror who was a teacher who indicated that juror would have a problem if the case went over the next day. And there was another juror who was a paramedic who indicated that juror also would have a problem if the case went over the next day. So the court had concerns of problems if the case were to go over into the next day. So that was definitely an issue that the court had before.
Mr. Dakin, didn't the trial court, and I'm remembering again, I may not be remembering clearly, but didn't the trial court make an offer to the jury for them to come back at 6 o'clock the next day after the work day to do their deliberations, or am I incorrectly recalling that as well?
I believe that's correct, Your Honor. But as the day went on...
But the jury declined that offer.
Yes, that's correct. That's correct. The jury wanted to go forward. And interestingly enough, throughout this case, the court was working with the jury and really with the participants in the case to keep this case moving along. The only time that the appellant asked for a continuance was at 4:18. And that was at the time when they took a break when the detective was on the stand. That was at the point where there was some discussion about the DVD, and there was some concern about the DVD that the court expressed. We acknowledge that. And it was at that point that defense counsel stated that generally there would be some prejudice to their client if the court were not to continue the case over to the next day. But they never said anything about, we need the time to play this DVD, we have to have this time. They just simply said we would be prejudiced if we have to go forward today. And the court said, well, in essence, let's keep going and see where we are. And they went forward. Now, at 6 o'clock, and I think that's where you really have the key to this thing, at 6:12 specifically, the state rested their case, and there was some more discussion at that point. And at that point, the defense announced that it was not going to publish the DVD. The defense did not object at that point. The defense did not say, Your Honor, we're not going to publish this DVD because we don't have the time to publish it. They simply said, Your Honor, we're not going to publish the DVD. Now, I would think that would give the trial court the thought, at least, that, well, I've got an extra hour and 40 minutes here that I can deal with. Perhaps the jury may want to play this, and that's what the defense counsel suggested to the court. They said, we're not going to play this, Judge, but we'll suggest in our closing argument that the jury may wish to play this. And we'll leave it to the jury to decide whether they want to do that. So the court, I think, probably felt that it had a little more time to deal with at this point. The court then asked again of the jury, do you want to go forward with the case at this point? And the jury said yes, that they did. Now, it's not only just a question of the fact that the judge is asking the jury. We know that the judge is also looking at that jury, and is looking at the participants as well. And the judge, as the court in the Woodall case, which is a Supreme Court case that we say is controlling precedent in this case, and it's cited at page 9 of our brief, says that the court is in the best position to observe the participants and see whether or not anybody is fatigued, to see if the jurors are fatigued, see if they're having difficulties paying attention, and so forth. And clearly this wasn't happening. The jury wanted to go forward. the judge obviously saw that the jury was ready, willing, and able to do so. That happened again at approximately 9:15. That's when 9:14. At that time, there was another break, and the court asked the jury to consider if it was confident that it had the mental alertness to give the trial what it deserved. There was a short break. The jury said it was ready, and that it wanted to go forward. And at 9:42, the jury retired to consider their verdict. At 11:37, the court indicated that it was concerned, and it brought the jury out, and at that point asked them if they still felt that they were in the mental state to pursue the cause. The jury said that they were. And again, they asked if they were progressing towards a verdict, and the jury said that it was. So again, the court was very knowledgeable as to what the state of the jury was. So we know for a fact that the jury was in a good position to be able to continue and complete this case during the day, during the rest of that day. Now, what about this DVD? Well, it's interesting that, as I pointed out before, the defense never objected specifically that they didn't have the time to play the DVD until the motion for new trial. And that, of course, is not appropriate. You have to make your objections contemporaneously. And I think that's important in this case, because I would suggest to this court that perhaps if the defense really meant it and said to the court at 6:15, Judge, we have decided that we don't have the time to play this DVD, even though it's important, and we would ask you to continue this over to tomorrow, perhaps the judge may have done so, perhaps the judge wouldn't have. We don't know the answer to that. And the reason we don't know the answer to that is because there was no contemporaneous objection, and the judge never had the opportunity to make that decision. So I think that is something that this court has to take into consideration in determining whether or not the court abused its discretion in continuing this case forward. But I think the reality is that it wasn't that important to their case. They didn't talk about it very much in closing argument at all. They didn't talk about it very much in the direct examination of the defendant. When they got to closing argument, the only reference to the tape at all was, ladies and gentlemen of the jury, I'm not sure if that's the exact pronunciation, but at least members of the jury, there's this tape, and if you want to look at it, you're welcome to look at it. But they didn't go into any specifications as to why it would be important for the jury to look at it, what about the tape that was important to look at, or anything to deal with it. So I don't think that the defense itself felt that it was that important. And I think that goes to the issue of prejudice. And I think that it shows that there was absolutely no prejudice to the defense in this case, in the fact that the court went ahead with this case into the late hours of the evening and took this case to the conclusion. And I think Your Honor pointed out something very important in the fact that this jury came back with lesser included offenses. I don't agree with counsel, with all due respect, that coming back with lesser offenses amounted to a compromised verdict. I think it shows that the jury cared about this case. And I think that in the 2 hours that they considered this case, that they cared enough and considered the evidence very carefully. And as a consequence, they came back with what they felt to be an appropriate verdict. There is absolutely nothing in this record that indicates that this jury was not paying full attention to this case. And there is absolutely nothing in this record that indicates that this DVD was so important that the defendant was prejudiced to the extent that this court can find that the trial court abused its discretion in taking this case and continuing it into the evening as the jury wished to do. So on that issue, we would ask that this court affirm.
One question about that. Was there any objection by the defense throughout the course of the day that the state was using too much of its share of the time?
No.
I mean, if the lawyer said, well, this case is going to take one day, I suppose if I were in the position of a defense lawyer in that case, I might argue, hey, wait a second, you can't take until 6 o'clock. You've got to give me part of the day. Was there any discussion like that?
No, there was not, Your Honor. There was no objection whatsoever that the state was taking too much time. And in fact, the defense only put on the defendant as their case. So it was only from the defense standpoint the one witness, and of course if they wanted to put on the DVD, they could have done so. So again, I think that underscores the fact that this was supposed to be a one-day case. It should have been a one-day case, and everybody knew it was to be a one-day case. So again, we don't feel that the court abused its discretion under the circumstances, and certainly without a specific objection that the court would have had the opportunity to rule on, should this court overrule and reverse on that issue. Very quickly on the question of the judgment of acquittal, the statute...
In regards to the counsel's request for a judgment of acquittal in reference to the sexual performance of a child charge, counsel relies on a federal court case, the case of Lane versus MRA Holdings.
Yes.
Can you distinguish the Lane case from the facts of this case?
I'm not that familiar with the Lane case, Your Honor, but I think that we would submit that the Schmidt case, which is the Florida Supreme Court case, is actually the controlling case in this case, and that Lane would not really be applicable. And the reason that we would say that, Your Honor, is because Schmidt really defines the Florida statutory elements, and I don't think Lane really talks in terms of the Florida statutory elements in the case. And what Schmidt says is that, first of all, you have to have an intentional act of sexual indulgence. Secondly, the Schmidt court pointed out that any type of sexual conduct involving a child constitutes an intrusion upon the rights of that child, whether or not the child consents. And then finally, the court pointed out that if the purpose of the acts was the intentional exploitation of, in that case, the defendant's daughter for a sexual purpose, then the conduct was considered lewd under the statute. Now, in Schmidt, what happened was the defendant had taken numerous photographs of his daughter in the nude. Nothing particularly sexual about them per se, but they were pictures of her swimming in the nude. They were general pictures of her in nude photography. There was one photograph, or video rather, of her taking off her clothes along with a girlfriend down to her panties. And so forth. And the court ruled that it was a decision for the jury, and I think Your Honor picked up on that, that it was a decision for the jury to determine under the totality of those circumstances whether or not those photographs constituted lewd photographs. We would also rely on the Rosen case, which is out of the 5th District, and we cited page 33 and 34 of our brief, and that case is actually a case of lewd and lascivious conduct, but I think it applies here in this sense. In that case, there was a teacher that was continually touching the students in various ways. The teacher would touch the children's breasts, for example, or the buttocks in kind of an allegedly friendly manner. And the court in that case held that it was a jury question based on the totality of the circumstances, whether the acts were committed in a lewd and lascivious manner. And we would submit that this is a case that is exactly under those circumstances. The totality of the circumstances here gave rise to a jury question whether or not the photographs, and there were really 2 photographs that the court looked at, constituted lewd and lascivious conduct. And I'll be very brief about the circumstances. 1, it was 1 o'clock in the morning and they were alone. 2, he gave her alcohol to drink. 3, he admitted that he gave her a massage and was doing some caressing behavior, which he told the police that was beyond what he really meant to do as an artist. 3, there were close-ups of the genital area. 4, there was a close-up of the appellant manipulating the girl's nipple, which could be considered as attempting to stimulate an aroused state. And finally, she was physically attacked by him. So when you take all of those circumstances, I think it would have been totally inappropriate for the trial court to grant a judgment of acquittal in this case. That being the case, the court correctly denied the motion, and we would ask that the court affirm in this case. Thank you.
All right, thank you, sir.
If it may please the court, the Woodell case is distinguishable. In that case, there was no evidence. There's no indication that all of the evidence was not presented and reviewed. And in that case, again, there was never any emphasis on efficiency. And that's what we have here replete throughout this trial. And again, there is no record evidence as to why the case could not have been held over to the next day for closing arguments. This jury was willing to forego dinner for efficiency, and the emphasis on efficiency and speed was at the expense of the client's right to a fair trial, denied him due process, and really effective assistance of counsel. Thank you.
All right, thank you. Thank you both. That completes our calendar for the afternoon. The court will be in recess.